Please proceed.
Good afternoon, Your Honor. My name is Christopher Reyes. I represent Sarah O'Malley. My client is seeking that the court deny Southeast motion to intervene. The court should deny Southeast motion to intervene for 3 reasons. First, they do not have a legally protectable interest. Second, their interest is not impaired or impeded by the present case. And third, they are adequately represented by the current defendant. SE's interest is not legally protectable because it's both for 2 reasons. There's an economic interest and a speculative interest. The courts have seen it as this legally protectable interest being separated into these 2 clauses. I will first attack the economic interest. If Sarah O'Malley succeeds in the present case.
But what I hear opposing counsel arguing is that a Southeast interest derives from the housing fund agreement. Do you challenge that that's a legally protectable interest?
Yes, I do. It is not a legally protectable interest because it is purely economic.
Why?
The courts have said that for example, Mount Holly, that if the intervener is simply looking for a way of saving money or making more money, then it is an economic interest. Their contract will remain the same with Beautiful Living, and the housing fund agreement will remain the same in every respect except paragraph 9, which would be declared unconstitutional.
Isn't that at the heart of their claim then, that if paragraph 9 gets declared unconstitutional and therefore essentially there's the housing fund agreement without paragraph 9, that they'll still have to pay $150,000 but have to defend litigation, and that basically their interests under that housing fund agreement could change as a result of the potential outcome of this litigation? Isn't that a legally protectable interest, their rights and obligations under a contract?
No, because counsel has also said that their main interest is the contract. The housing fund agreement never came in until after the contract. The contract will still remain the same.
When you refer to the contract, counsel, are you referring to a different contract?
Yes, I'm referring to the contract between Beautiful Living and Southeast to actually purchase the property in question.
Okay.
That contract was done before the housing fund agreement came in, and the contract would only be passed if the rezoning had taken place. Housing fund agreement was only done to try to coax some of the neighbors who were not happy with the idea of rezoning into actually rezoning.
But how is that relevant to defining their interests, what their interest is or not?
Because they say that is their main interest in the housing fund. If the contract is their main interest in the housing fund agreement, and paragraph 9 are not really the main interest in their case, then, and it just shows.
But what I hear opposing counsel saying is that their main interest is the housing are the interests derivative from the housing fund agreement.
But they've claimed 2 different interests, and they've claimed both.
But but that's something they can do. I mean, they can claim 2 different interests, and this court is particularly leaning toward thinking that an interest that's derivative from the housing fund agreement may be potentially one that Rule 24 finds acceptable, and so I'm wondering if that's the case, how you address that. How would you have this court address that?
I would have the court address it the same way Mount Holly did. In Mount Holly, Rigod, who was trying to intervene, his only interest is that there would have been less money available which he can recover from. The reason was he already had a separate case he was involved in due to a wrongful death damages. In the same exact case, Southeast, there's another case going on that Southeast can intervene in, which directly affects the rezoning, and not so much that this is a First Amendment constitutional right.
But how is Mount Holly analogous to this case? Because in Mount Holly, the intervener, the party who was seeking to intervene, actually didn't have any kind of contractual rights at issue. They weren't part of the insurance, arrangements, contractual arrangements. They were completely outside of any kind of legal, contractual protection. But here it seems that their interests were outside of any legal protection. But here it seems that Southeast interests are part of a legal contractual protection. In other words, the housing fund agreement.
Right, but again, the main issue is those $150,000. Mm-hmm. If assuming that Sarah O'Malley is successful in the present case, those $150,000 will have to be put into the housing fund agreement. But that is it. It's $150,000. The rest would remain the same. Mount Holly said that if Rigod, the intervener, his only concern is the money, then it is a pure economic interest. And that's how it's analogous here. It has to do with all about the $150,000. The second interest, speculative interest, the courts have defined that an interest contingent upon the outcome of other pending litigation and purely speculative is not a legally protectable interest. This is also taken out from Mount Holly. In Mount Holly, Rigod, once again the intervener, his interest is purely speculative because it's contingent upon his prevailing against Maria International and Sandy Lake's property. Again, there was a separate case in that intervening. There was a separate case that Rigod was a part of, and they needed that first to clear through before this could actually have any effect on his other case. Similarly here, Southeast would first have to successfully appeal the rezoning, Sarah O'Malley would successfully appeal the rezoning issue before there's actually any problem with the contract.
Meaning the contract between Beautiful Living and...
Right, between the contract between Beautiful Living and Southeast.
But if I go back to the housing fund agreement, do you think that the interest eroded from that is speculative or not?
Yes, I do, actually. I think it is speculative because they still will have the housing fund agreement set in place, and the housing fund agreement is assuming that, aside from paragraph 9, is there to help people, to help the current residents move. They would still...
How is that speculative? How does that make it speculative?
I can't answer that one right now, Your Honor. If I can file a supplemental motion.
That's fine, thank you.
Okay, thank you. So finally, the third interest that, the second prong to the element is whether Southeast interest is impaired or impeded by the present case. The subject matter of the present case is the constitutionality of paragraph 9 of the housing fund agreement. Therefore, any ruling in the present case will create stare decisis based on the First Amendment only. Minnesota 88 has managed to combine the subject matter interest, which seems very close to the first element, together with the impair impediment element and stare decisis. The exact language says that where a party seeking to intervene in an action claims an interest in the very property and very transaction that is the subject of the main action, the potential stare decisis effect may supply that practical disadvantage which warrants intervention as of right. In this case, the appellant's subject matter interest is not similar to, the intervener's interest is not similar to the subject matter of the case. Therefore, there is no way that stare decisis can negatively affect them later on, because their interest and their contract has nothing to do with First Amendment rights.
Isn't part of that inquiry whether Southeast would have any way to protect its interests? So here, how else could Southeast protect its interests in, for example, the changing rights and obligations of the housing fund agreement? If I buy that argument, what can Southeast do?
Southeast can actually intervene in the current in another case going on at the same time of another resident who has actually appealed.
But that case doesn't really does that case essentially change the housing fund agreement? Would it change the housing agreement? I thought that case, if you're referring to the Mark Smith case, I thought that case had to do with challenging the rezoning itself.
Which is what Southeast claims is their real interest. And if their interest is this contract, then it has nothing to do with the subject matter of this case, of the present case, which is the First Amendment rights. Finally, the last element of Rule 24 says that SE cannot intervene if they are adequately represented by the city. And we claim they do. That they are, in the present case, the city will be defending paragraph 9 of the Housing Fund Agreement. Both the city and Southeast are equal parties to the Housing Fund Agreement, and an outcome favorable to Sarah O'Malley would yield the same result for both Southeast and the city. According to the United States v. State of Georgia, we presume that a proposed intervener's interest is adequately represented when an existing party pursues the same ultimate objective as the party seeking intervention. To parallel the cases in US v. Georgia, the ultimate goal was to eliminate the impact of segregation on students. There was a, may I please
Yeah,
finish my last slide?
you may have me to conclude your
Thank you.
statement.
There was no bad faith or gross negligence on the current board in pursuing this goal. There was nothing negative about them trying to pursue the same goal. Therefore, in the same instance, in this case, Southeast is adequately represented because the city is going to pursue the same goal as them, and there is no bad faith in the city trying to pursue that same goal.
Thank you, Council.
Thank you.